Before we begin, a quick and important disclaimer. The information provided in this video regarding legal careers, salary data, historical trends, and professional earnings is for educational and entertainment purposes only. This content does not constitute professional legal, financial, or career advice. Salary figures, economic statistics, and historical data points are based on aggregate historical records, Department of Labor archives, and industry surveys which may not reflect the experiences of any individual practitioner. Market conditions, geographic location, and individual expertise significantly influence potential outcomes in the legal profession. Viewers should conduct their own due diligence and consult with qualified career counselors or financial professionals before making decisions regarding their education, career path, or professional investments. Every single year in the United States, approximately 680,000 to 750,000 marriages come to an end. While this statistic is often viewed through a lens of social tragedy or personal upheaval, there is a parallel narrative that rarely makes the headlines: the massive multi-billion-dollar economic engine that powers these dissolutions. We are looking at an industry that generates an estimated $50 billion in annual revenue, and at the center of this financial ecosystem stands the divorce lawyer. There is a persistent myth that the legal profession is a monolithic path to high net worth, yet the historical data tells a much more complex and startling story. In 1960, the average family law practitioner was barely out-earning a mid-level manager in a manufacturing plant. Fast forward to the present day, and the top 1% of matrimonial attorneys in markets like Manhattan or Beverly Hills are commanding hourly rates that exceed $1,500. This is not just a story of inflation. It is a story of a radical shift in American law, sociology, and the commodification of domestic conflict. By the end of this deep dive masterclass, you will understand the precise historical inflection points that turned divorce law from a taboo basement practice into one of the most lucrative niches in the American legal system. We are going to deconstruct the golden age of litigation, examine the no-fault revolution of the 1970s that restructured the billable hour, and look at the hard data comparing historical earnings across 5 decades. Whether you are a law student calculating your future ROI, a practicing attorney looking to benchmark your firm, or simply a student of American economic history, this analysis will solve the mystery of why some divorce lawyers struggle to keep their lights on while others operate out of glass towers. We are moving beyond the surface-level tropes to look at the raw, unfiltered numbers that define the cost of moving on in America. To understand where the money is today, we have to look at the statistical wasteland of the pre-1970s era. Before the landmark shifts in legislation, divorce law was fundamentally different from the high-stakes corporate-style litigation we see today. In the 1940s and 1950s, divorce was fault-based. This meant that to get a divorce, one party had to prove fault: adultery, cruelty, or abandonment. From a salary perspective, this was a high-friction, low-volume business model. Attorneys could not simply process cases, they had to act as quasi-investigators. Historical trends show that during this era, family law was often viewed as the bottom rung of the legal ladder. In 1950, the median income for all lawyers in the U.S. was approximately $9,000 per year. When adjusted for inflation, that is roughly $115,000 in today's currency. However, family law practitioners consistently trailed this median, often earning 20 to 30% less than their counterparts in corporate or tax law. The primary reason for this suppressed earning potential was the social stigma discount. Because divorce was culturally discouraged, the demand was artificially suppressed. Lawyers who specialized in divorce were often marginalized by the American Bar Association and excluded from prestigious white shoe firms. This led to a fragmented market of solo practitioners who relied on flat-fee arrangements. A standard divorce in 1955 might cost a client $200. Even when accounting for the relative value of the dollar, the overhead of maintaining an office and a small staff made it difficult to achieve significant wealth. The potential outcomes for an attorney in this era were limited to a comfortable middle-class existence, far removed from the private jets and luxury estates associated with modern super lawyers. Everything changed in 1969 when Governor Ronald Reagan signed the California Family Law Act, which introduced the concept of no-fault divorce. This was the most significant economic catalyst in the history of the legal profession. By removing the requirement to prove wrongdoing, the barriers to entry for ending a marriage collapsed. The statistics are undeniable. Between 1960 and 1980, the divorce rate in the United States more than doubled, rising from 2.2 per 1,000 people to 5.2 per 1,000. For lawyers, this meant an explosion in volume. Let's look at a case study of this transition. In the mid-1960s, a divorce lawyer in a major city might handle 10 to 15 active cases at a time, most of which were bogged down in the evidentiary phase of proving fault. By 1975, that same lawyer could leverage the no-fault system to manage 40 to 50 cases simultaneously. The shift from proving guilt to dividing assets moved the focus of the practice from the bedroom to the boardroom. This is where the billable hour revolution truly took hold in family law. Instead of a flat $500 fee to get the papers, lawyers began charging $50 to $75 per hour for the arduous process of discovering and valuing assets. The historical data from the 1970s shows a sharp upward trajectory in attorney compensation. As the Me generation embraced individual fulfillment over traditional structures, the complexity of marital estates increased. The rise of two-income households and the expansion of the American middle class meant there were more houses, pensions, and investment portfolios to fight over. By 1980, the top-tier divorce lawyers in Los Angeles were starting to report annual incomes exceeding $200,000. An astronomical sum for the time, equivalent to nearly $750,000 today. We must also consider the specialization premium. As the law became more technical, the general practitioner who did a little bit of everything was replaced by the family law specialist. Statistical reviews of the 1980s show that attorneys who obtained board certification in family law saw their average hourly rates jump by 40% compared to generalists. This era saw the birth of the celebrity divorce lawyer, individuals like Marvin Mitchelson, who pioneered the palimony suit. These high-profile cases didn't just earn massive fees. They functioned as global marketing campaigns, driving up the perceived value of specialized legal counsel. To provide a concrete comparison, let's look at the growth of the Legal Services Price Index versus the Consumer Price Index, CPI. Between 1980 and 2000, the cost of legal services for divorce and family law outpaced general inflation by nearly 3 to 1 in several metropolitan areas. This suggests that the salary growth of divorce lawyers was not merely a reflection of the economy, but a fundamental shift in the value of the service provided. The lawyer was no longer just a processor of paperwork. They became a strategic financial architect. In this deep dive, we are also going to examine the geographic variance data. Historically, the salary of a divorce lawyer in a high-asset state like Connecticut or New York has remained significantly higher, sometimes by as much as 150%, than a lawyer in a low-asset or rural state. This is because divorce law is one of the few legal fields where the lawyer's salary is directly correlated with the value of the subject matter. If you are litigating a divorce involving a $10 million estate, the potential outcomes for the attorney's fee are exponentially higher than a divorce involving a $50,000 estate, even if the legal work is substantially similar. As we move forward in this series, we will break down the precise mechanics of how these salaries are calculated today, including the retainer model and the efficiency gap. We will analyze why, despite the high average salaries, the churn rate for young associates in family law is among the highest in the profession. The history of the divorce lawyer's salary is a history of the American family's evolution, from a social contract to a financial one. Stick with us as we peel back the layers of this $50 billion industry, starting with the raw data from the Department of Labor and ending with the modern-day strategies used by the highest-paid attorneys in the country. To understand the true trajectory of divorce lawyer salaries, we must analyze the Bureau of Labor Statistics data from the transition point of the mid-1980s into the early 2000s. This period represents the professionalization of family law. Imagine a lawyer named Michael practicing in Chicago in 1985. According to historical trends, the median salary for an attorney at that time was roughly $40,000. However, Michael, specializing in the burgeoning field of complex marital dissolution, was beginning to see the impact of high-stakes asset division. The 1980s introduced a surge in dual-income households and the proliferation of 401k plans, which were established only a few years prior in 1978. These new financial instruments transformed a standard divorce from a simple custody battle into a forensic accounting project. Historical data suggests that as the complexity of the marital estate increased, so did the billable hour. In 1985, a mid-level family law practitioner in a major metropolitan area might charge $100 per hour. By 1995, that rate had doubled. This was not merely inflation. It was a reflection of the increased specialized knowledge required to navigate the Retirement Equity Act of 1984, which governed how pensions and retirement accounts were split. For a lawyer like Michael, the ability to draft a qualified domestic relations order or QDRO became a high-value skill set. This specific technical expertise allowed practitioners to move away from the lower income brackets of general practice and into a specialized tier where potential outcomes for their own annual revenue began to exceed $150,000. By the time we reached the late 1990s and the early 2000s, the statistical landscape shifted again due to the dot-com bubble. This era created a new class of wealth in the United States. Divorce lawyers in tech hubs like San Jose or Seattle began seeing cases involving unvested stock options and intellectual property valuations. Case studies from this period highlight that the top 10% of family law attorneys were no longer just legal advocates. They were acting as sophisticated financial negotiators. The Bureau of Labor Statistics reported that by 2002, the mean annual wage for lawyers had climbed to approximately $105,000. Yet, in the niche of high-net-worth divorce, the historical records of top-tier firms show partners bringing home between $300,000 and $500,000. Now, let us fast-forward to our current year of 2026. The economic profile of a divorce lawyer has undergone a digital and algorithmic transformation. Consider a modern practitioner, let us call her Sarah, working in Manhattan. In 2026, the landscape is defined by the great wealth transfer and the rise of digital assets. Sarah's salary is not just a product of her time but of her efficiency. The integration of AI-driven discovery tools has changed the billable hour model. While some feared technology would depress salaries, the data suggests the opposite for elite practitioners. By using software to categorize thousands of financial transactions in seconds, Sarah can handle a higher volume of high-stakes cases while maintaining a premium hourly rate, which in 2026, for a specialist of her caliber, often hovers around $900 to $1,200. Let us break down the math of a modern 2026 salary in this field. If an attorney like Sarah targets 1,800 billable hours a year, a standard industry benchmark, at an average rate of $600 per hour, the gross revenue generated is $1,080,000. However, the statistical reality of a lawyer's take-home pay involves a deep dive into overhead and the partner-to-associate ratio. In 2026, high-end family law firms often operate on a 40% profit margin. This means after paying for office space in a prime location, malpractice insurance, a team of paralegals, and advanced legal research subscriptions, the lead attorney's personal income might settle around $432,000. This figure aligns with current 2026 industry surveys that place top-tier family law partners in the top 2% of American earners. We must also examine the historical trends of the recession-proof myth. It is often said that divorce lawyers thrive when the economy crashes. The data from the 2008 financial crisis provides a nuanced counter-argument. During that period, while the need for divorce remained constant, the ability for clients to pay for it plummeted. Statistical reviews show that in 2009 and 2010, many divorce lawyers saw a 15 to 20% dip in their personal income because marital homes, often the primary source of legal fees, were underwater. People were forced into pro rata representations or deferred their divorces entirely. This period taught the industry a vital lesson. The salary of a divorce lawyer is inextricably linked to the liquidity of the American middle and upper classes. In 2026, we see a different trend. The volatility of the current market and the rise of cryptocurrency have made the discovery phase of a divorce more lucrative than ever. Statistics show that 1 in 4 modern divorces now involve some form of digital currency or decentralized finance assets. Lawyers who have adapted to this trend by becoming crypto-literate are commanding a 30% salary premium over their peers who stick to traditional asset classes. This is a clear example of how specialization within a niche creates an outlier in the general salary data. To give you a better understanding of the salary hierarchy, we can categorize the 2026 divorce lawyer earnings into 3 distinct tiers based on aggregate national data. Tier 1 consists of the high-volume, low-margin practitioners. These are often solo attorneys in suburban or rural areas. Their annual salaries typically range from $75,000 to $130,000. They rely on standardized forms and flat-fee arrangements for uncontested matters. Tier 2 is the mid-market specialist. These lawyers work in mid-sized firms in cities like Atlanta, Denver, or Dallas. They handle contested litigations and have reached a level of local prominence. Their salaries usually sit between $180,000 and $350,000. Tier 3 represents the boutique elite. These are the attorneys featured in national magazines, representing celebrities, athletes, and ultra-high net worth individuals. In 2026, these individuals can see annual compensation ranging from $600,000 to well over $2 million when bonuses and firm profit sharing are factored in. But there is a hidden variable in these numbers that most people overlook: the psychological tax. While the salaries look impressive on a spreadsheet, the historical turnover rates in family law are nearly double those in corporate or real estate law. The data suggests that the high compensation is, in part, a risk premium for the emotional labor involved. In 1990, a study of lawyer satisfaction showed family law at the bottom of the list. By 2026, even with better work-life balance initiatives, the attrition rate for associates in this field remains high, which ironically keeps the salaries for experienced seniors elevated due to a perpetual talent shortage. As we continue this masterclass, we have to ask, what happens when the very nature of marriage changes? We have looked at the past and the present, but the most shocking data point lies in the shift toward prenuptial agreements among the younger generation. How does a lawyer's income change when the fight is settled before the wedding even starts? We are about to look at the pre-litigation revenue model that is currently saving the industry from a projected decline in traditional divorce filings. In the next part, we will dismantle the billable hour itself. We will look at the secret efficiency multipliers that allow a $200,000 a year lawyer to suddenly jump to $500,000 without working a single extra hour. We will explore the value-based pricing revolution of the 2020s and why the smartest lawyers are actually hoping their clients' estates are more complicated, not less. The shift from hourly billing to result-based incentives is the biggest goldmine in legal history, and we have the internal firm data to prove it. Stay with us as we head into the mechanics of the million-dollar solo practice. The concept of the million-dollar solo practice in 2026 is not a theoretical aspiration, but a statistical reality driven by a radical departure from the traditional law firm hierarchy. To understand how a single practitioner can generate 7 figures in personal income, we have to look at the intersection of extreme specialization and technological leverage. Imagine a lawyer named David operating in Austin, Texas, in the current year of 2026. David does not have a sprawling office in a downtown skyscraper, nor does he employ a dozen hungry associates. Instead, David represents the new vanguard of the legal economy, the lean, high-margin specialist. Historical trends show that in the early 2000s, a solo practitioner's ceiling was often dictated by the number of hours they could physically sit at a desk. If you worked 2,000 hours a year and billed $250 an hour, your gross revenue was capped at $500,000 before taxes, malpractice insurance, and rent. In 2026, David has shattered this ceiling by implementing what industry experts call the efficiency multiplier. By utilizing advanced AI-driven forensic accounting tools, David can perform deep-dive asset traces that used to take a team of junior associates weeks to complete. In a case study involving a high-stakes dissolution of a tech entrepreneur's estate, David used an automated discovery platform to scan 10 years of blockchain transactions and traditional bank records in under 4 hours. Historically, this level of due diligence would have cost the client $40,000 in associate billable time. David, however, bills a flat value-based fee of $25,000 for the discovery phase alone. He is doing 4 hours of work for $25,000, which mathematically translates to an effective hourly rate of $6,250. This shift toward value-based pricing is the primary engine behind the modern million-dollar salary. In the old model, the lawyer was incentivized to be slow because more hours meant more money. In the 2026 model, the market rewards the outcome and the speed of the resolution. If David can use his expertise to secure a settlement that protects $10 million in intellectual property for his client, the client is often more than willing to pay a premium flat fee, rather than watch a billable hour clock tick indefinitely. Statistical reviews of solo practitioner tax filings in high-growth states suggest that those who transition to at least 50% flat fee or hybrid billing saw their net profit margins jump from a historical average of 35% to over 65%. We must also analyze the explosive growth of the prenuptial and postnuptial revenue stream. Imagine if, instead of waiting for a marriage to fail, a lawyer could generate consistent, high-margin revenue at the beginning of the union. In 2026, the cultural stigma surrounding prenups has largely evaporated among Gen Z and millennial professionals. Data from 2025 and early 2026 indicates that nearly 40% of new marriages involving individuals with assets over $100,000 now include a legal agreement. For a lawyer like David, this is the ultimate recurring revenue model. A standard high-end prenuptial agreement in a market like Austin can command a fee between $5,000 and $15,000. Because David has built a modular, software-assisted drafting system, he can finalize a bespoke, ironclad agreement in approximately 3 hours of total human labor. Let us break down David's annual earnings for 2026 using this diversified model. If he handles 40 prenuptial agreements at an average of $7,500 each, that is $300,000 in low-stress, clean revenue. If he then takes on just 10 high-net-worth divorce litigations per year with an average total fee of $80,000 per case, he adds another $800,000 to the books. His total gross revenue hits $1.1 million. Because his overhead is minimized through a virtual office, cloud-based practice management, and on-demand paralegal support, his total expenses might only be $150,000. David's take-home pay is $950,000. This is the statistical blueprint for the top 1% of solo practitioners in the modern era. However, achieving these potential outcomes requires a step-by-step mastery of what we call the legal tech stack. In 2026, a lawyer's salary is increasingly a reflection of their IT budget. For every dollar David spends on high-tier automation software, he is effectively buying back 10 hours of his own time. This is a massive departure from the 1990s, where a lawyer's biggest expense was a physical law library and a full-time secretary. Case studies of failed solo practices in the current year often point to a resistance to automation as the primary cause of financial stagnation. Lawyers who insist on manual document review or traditional hourly billing for routine tasks are finding their margins squeezed by clients who are increasingly tech-savvy and price-sensitive. Another critical factor in this salary deep dive is the arbitrage of geography. In 2026, David can live in a state with no income tax and lower cost of living while representing clients in high-wealth jurisdictions, provided he is barred in those states or utilizes co-counsel arrangements. This allows for a double dip on the salary, earning Manhattan-level fees while maintaining Midwest-level expenses. We are seeing a statistical migration of family law talent out of high-tax cities like San Francisco and into tax-friendly hubs, effectively increasing their real-world purchasing power by 25 to 30% without changing their gross billings. But there is a specific technicality we haven't touched on yet, and it is perhaps the most lucrative part of the modern divorce lawyer's toolkit: the shadow estate. In 2026, the rise of DeFi or decentralized finance has created a massive demand for lawyers who understand how to find hidden money in liquidity pools, staked assets, and NFT vaults. This isn't just a niche. It has become a standard part of the matrimonial search. Historical trends show that in 2015, perhaps 1 in 100 cases involved digital assets. In 2026, that number is closer to 1 in 3. Lawyers who can successfully navigate a crypto audit are charging what is known as a technical premium. This premium can add an additional 20 to 50% to the total case fee. Imagine a scenario where a spouse has attempted to hide $2 million in a series of privacy coin transactions. The average lawyer might miss this entirely. A 2026 specialist who identifies these assets not only secures a better outcome for their client, but also justifies a significantly higher fee structure based on the found value. This is where the divorce lawyer stops being a mere counselor and starts acting as a bounty hunter for marital equity. As we look at the data, one thing becomes clear. The gap between the average divorce lawyer and the elite specialist is widening at an accelerating rate. The middle class of family law is disappearing. You are either a volume-based form filler, struggling to compete with DIY online services, or you are a high-level strategist like David, commanding six-figure fees for single cases. The salary data for 2026 shows a K-shaped recovery within the legal profession itself. But what about the burnout index? Is this million-dollar salary worth the psychological toll that has historically plagued the profession? The data from 2026 suggests a surprising trend in work-life integration that is actually driving salaries even higher for those who stay in the game. In the next part, we are going to look at the dark side of these numbers. We will analyze the statistical correlation between high-earning attorneys and high-stress health outcomes. More importantly, we are going to reveal the exit strategies that the wealthiest divorce lawyers use to retire a decade earlier than their corporate counterparts. we are entering the territory of wealth preservation for the lawyers themselves, because making the money is one thing, but keeping it in an industry designed to burn you out is a completely different challenge. Stay tuned as we break down the golden handcuffs of family law. The concept of the golden handcuffs in family law refers to a specific economic trap where high earning potential is offset by massive overhead and an even higher psychological toll. To understand the statistical reality of this, we must look at the burnout index. Historical trends in the American Bar Association's longitudinal studies suggest that family law practitioners report higher levels of secondary traumatic stress compared to almost any other legal specialty. In 2026, as the volume of high-conflict litigation increases due to the complexity of digital lives, this index has reached a critical threshold. Imagine Jennifer, a highly successful partner at a boutique family law firm in Miami in 2026. On paper, Jennifer is an American success story. She brings home a personal income of $550,000 a year. However, the data reveals the cost of that salary. Jennifer's firm requires her to be available for emergencies 24 hours a day, 7 days a week. In high-stakes custody battles, a Friday evening can quickly turn into a weekend-long litigation session if a client fears a child is being taken out of the jurisdiction. Statistics from 2025 show that lawyers in the top 10% of the earnings bracket for family law work an average of 65 hours per week. When you break down Jennifer's $550,000 salary by her actual hours worked, her effective hourly take-home pay is roughly $162. While still high, it is a far cry from her $750 billable rate. The golden handcuffs tighten when we look at the lifestyle inflation statistics associated with this profession. Case studies of elite attorneys in major U.S. hubs show a direct correlation between salary increases and the expansion of fixed costs. In 2026, to maintain the appearance of success required to attract high-net-worth clients, Jennifer's overhead is staggering. High-end office space, memberships to exclusive social clubs for networking, and the necessity of a top-tier support staff eat into her gross billings. Data suggests that for every $100,000 Jennifer earns above the median, her personal cost of living typically rises by $60,000. This leaves her in a position where she cannot afford to step back, even as the psychological tax begins to drain her. The health statistics for this sector of the legal industry are sobering. Historical records from the early 2000s already showed that family law practitioners had a 20% higher rate of chronic stress-related illnesses than real estate or corporate lawyers. In 2026, updated health surveys indicate that 35% of matrimonial attorneys in the United States suffer from some form of sleep disorder or anxiety-related condition. The irony is statistically significant. Divorce lawyers who spend their days deconstructing failed relationships have a divorce rate that is approximately 15% higher than the national average for other professional classes. This suggests that the very skills used to generate a high salary, aggressive negotiation, constant skepticism, and emotional compartmentalization, often negatively impact the lawyer's own personal outcomes. Because of these historical trends, the most successful lawyers in 2026 have begun implementing what is known as the 15-year exit strategy. This is a statistical model where an attorney aggressively maximizes their income for 15 years, while simultaneously building a diversified portfolio of passive income streams. The goal is to move from Tier 3 litigation into what we call the advisory or mediation phase. Let us look at a case study of a lawyer named Robert, who successfully executed this transition in 2026. Robert practiced high-conflict litigation in Chicago for 2 decades. At his peak, he was earning $700,000 a year. Instead of increasing his lifestyle costs, Robert invested 30% of his post-tax income into a combination of tax-advantaged retirement accounts and, notably, legal tech startups that automate the very tasks that caused his burnout. By the time he reached age 48, Robert shifted his practice exclusively to mediation. In the mediation model, the salary dynamics change. Robert no longer takes on the adversarial stress of a trial. He acts as a neutral third party to help couples reach an agreement outside of court. While his gross revenue dropped to $400,000, his overhead plummeted by 70%. He no longer needed a massive litigation team or expensive trial software. In 2026, Robert's net profit margin is actually higher as a mediator than it was as a litigator. More importantly, the data shows a 40% improvement in self-reported well-being scores for attorneys who make this shift. This represents the wealth preservation phase of the career, protecting both financial capital and human capital. We also have to consider the rise of the of-counsel position as a salary stabilizer. In the past, a lawyer either stayed a partner until they retired or they left the firm entirely. In 2026, statistical reviews of firm structures show a 25% increase in the use of the of-counsel role for senior family law specialists. In this arrangement, the lawyer provides high-level strategy and mentorship to younger associates, but does not carry the primary burden of the billable hour or firm management. They typically receive a base salary plus a percentage of the business they bring in. This allows them to maintain a salary in the $200,000 to $300,000 range while working 30 hours a week instead of 60. It is a statistical middle ground that allows the industry to retain its most experienced minds without burning them out completely. The financial data also reveals a fascinating trend in professional liability insurance. In 2026, insurance premiums for family law litigators have risen by 12% annually over the last 3 years. This is due to the increasing frequency of malpractice claims in high-asset divorces, particularly those involving complex tax structures or international assets. For a high-earning lawyer, this insurance is a mandatory and expensive cost of doing business. However, attorneys who move into mediation or prenuptial drafting see their insurance premiums drop by as much as 50%. This is another hidden raise that contributes to the shift in how the wealthiest lawyers are structuring their careers in the current year. As we analyze these numbers, we must ask, if the burnout is so high, why do so many stay in the litigation trenches? The answer lies in the potential outcomes of a single massive black swan case. Every divorce lawyer in the United States knows the story of the $100 million settlement, where the legal fees reach $5 million. These cases are rare, statistically occurring in less than 0.1% of all filings, but they act as a powerful psychological lure. It is the legal equivalent of a high-stakes lottery, and it keeps many attorneys in a state of perpetual high-stress readiness, hoping for the one case that will allow them to retire instantly. But what if the very nature of how we value legal work is about to be upended? We have talked about the psychological tax and the exit strategies of the elite, but there is a massive demographic shift happening right now that is changing the demand for divorce lawyers entirely. The silver divorce phenomenon is seeing people over the age of 60 end long-term marriages at record rates. This is a demographic with the most assets, the most complexity, and the least amount of time to waste in court. In the next part, we are going to dive deep into the silver divorce economy. We will look at how the aging baby boomer and Gen X populations are creating a brand new salary floor for family law practitioners. We will analyze why representing a 65-year-old with a $5 million pension is statistically more profitable than representing a 30-year-old tech founder with $20 million in unvested options. We are going to uncover the elder law hybrid model that is becoming the most stable and lucrative career path for the next decade. The numbers are shifting, and if you aren't looking at the age of the client, you are missing half the salary story. Get ready for Part 5, where we look at the graying of American divorce and the wealth that follows it. The graying of American divorce is not just a sociological trend. It is a financial gold mine that has fundamentally shifted the salary floor for family law practitioners in the United States. To understand why, we must look at the specific economic profile of the 50-plus and 65-plus demographics in the year 2026. Historical trends indicate that while overall divorce rates in younger generations have stabilized or even declined, the rate for those over the age of 50 has doubled since 1990, and for those over 65, it has tripled. From a legal salary perspective, this is the most lucrative shift in the history of the profession because of a concept we call the asset-to-conflict ratio. Imagine a client named James in 2026. James is 64 years old, a retired aerospace engineer living in Virginia. He and his spouse have been married for 38 years. Unlike a 30-year-old couple who may be fighting over a house with a massive mortgage and a mountain of student loan debt, James and his wife are sitting on a marital estate worth $4.5 million. This estate includes a fully paid-off primary residence, a vacation property in the Carolinas, 2 substantial 401k portfolios, a traditional pension plan, and a complex web of Social Security considerations. For a lawyer, James is not just a client. He is a high-stakes financial project. In the 1980s, a divorce for someone in James's position was statistically rare and often socially discouraged. Lawyers in that era were focused on custody battles and child support, which are emotionally draining but often lower margin due to the finite nature of the disputes. In 2026, the silver divorce economy moves the focus entirely to asset division, tax optimization, and long-term financial security. This shift allows attorneys to justify significantly higher retainers. Historical data from the mid-2020s shows that the average retainer for a gray divorce case in a major metropolitan area is roughly $15,000 to $25,000, compared to $5,000 to $7,500 for a standard domestic matter involving younger parties. The salary impact for a lawyer specializing in this field comes from the depth of technical expertise required. Let us look at the complexity of the Retirement Equity Act and its impact on modern earnings. In 2026, dividing a pension or a complex retirement portfolio requires a Qualified Domestic Relations Order, or QDRO. This is a highly technical legal document that tells a plan administrator exactly how to split a retirement account without triggering massive tax penalties. A general practitioner might charge a flat fee of $1,000 to draft a QDRO, but a silver divorce specialist in 2026 often builds this into a larger, comprehensive wealth division strategy that can command fees exceeding $50,000 for the entire case. Furthermore, the potential outcomes for an attorney's income are enhanced by the longevity of these cases. Silver divorces are rarely quick, because there is so much at stake, specifically the ability to survive for another 30 years without a paycheck. The parties are often willing to litigate for 18 months or more to ensure every cent is accounted for. For a lawyer, a case that lasts 18 months and involves a $4 million estate is a stable, high-revenue asset. Case studies from the current 2026 market show that an attorney carrying just 5 of these high-level gray divorce cases can easily clear a gross income of $300,000 annually before even touching their general caseload. We must also examine the rise of the elder law hybrid model. In 2026, the smartest family law practitioners are not just doing the divorce. They are capturing the entire legal life cycle of the client. When a 65-year-old gets divorced, they immediately need a new will, a new power of attorney, and a new trust structure. Historically, a divorce lawyer would finish the case and send the client elsewhere. Today, top-earning lawyers have integrated estate planning into their firms. This increases the lifetime value of the client. By providing a holistic post-divorce financial and legal restructuring, a lawyer in 2026 can add an additional $10,000 to $20,000 in revenue per client. Consider the Medicaid planning factor. In a silver divorce, one party may be concerned about future long-term care costs. Navigating the legalities of how a divorce settlement affects Medicaid eligibility is a specialized niche that did not exist in a significant way 30 years ago. Attorneys who have mastered this intersection of family law and elder law are currently the highest-paid specialists in the suburban U.S. market. They are not competing with the cut-rate, high-volume firms. They are acting as high-level consultants for the wealthiest generation in human history. Statistical reviews of the 2026 legal market suggest that baby boomers and older Gen Zers control over $70 trillion in wealth in the United States. As this wealth is divided through the legal system, the attorneys act as the toll-takers on the bridge of asset redistribution. This is why we see a 40% higher average salary for family lawyers in retirement destination states like Florida and Arizona, compared to states with younger, more debt-heavy demographics like Utah or Texas. The salary is not a reflection of the lawyer's hours, but of the wealth they are tasked with moving. There is also a fascinating Social Security arbitrage that divorce lawyers must now navigate. Under U.S. law, if a marriage lasted 10 years or longer, a divorced spouse may be entitled to benefits based on the other spouse's earnings record. In 2026, with the Social Security system facing increased scrutiny and adjustment, the strategic timing of a divorce filing can mean a difference of hundreds of thousands of dollars in lifetime benefits for the client. Lawyers are now charging premium advisory fees for this specific timing analysis. This was unheard of in the 1970s or 80s when the financial stakes of retirement were viewed through a much simpler lens. As we analyze the 2026 salary data, a clear pattern emerges. The silver lawyer is the most stable professional in the industry. While the marriage rate for 25-year-olds might fluctuate with the economy, the divorce rate for 60-year-olds is driven by deeper, more consistent psychological and economic factors. These clients have the money to pay, the assets to fight over, and the urgency to settle their affairs. This creates a high-income, low-volatility career path that is attracting the top talent in the legal field. But as the wealth involved in these cases grows, so does the sophistication of the methods used to hide it. We have moved beyond hiding cash under a mattress. In 2026, the digital footprint of a divorce has become a battlefield of its own. Attorneys are now having to become experts in high-tech surveillance, social media forensic analysis, and the psychological profiling of digital ghosts. The shift in salary we have seen due to silver divorces is only the beginning. There is a new darker driver of revenue in the 2026 legal market, the surveillance economy. In the next part, we are going to dive into the world of digital discovery. We will look at how a lawyer's salary in 2026 is increasingly tied to their ability to hack legally into the secret digital lives of their clients' spouses. We will explore the search history subpoena and why the most valuable person in a modern law firm isn't the lawyer, but the forensic IT specialist they keep on retainer. Get ready for Part 6, where we look at the high-cost world of digital infidelity and the data-driven divorce. In the transition from the physical world to the digital surveillance economy of 2026, the primary source of evidence in divorce litigation has undergone a radical transformation. Historically, a divorce lawyer's salary was often supplemented by the use of outside private investigators who would provide physical surveillance, photographs, and witness statements. In the 1970s and 1980s, this was a high-friction process that requires significant time and physical legwork. However, as we look at the statistical landscape today, the physical investigator has been largely replaced by the digital forensic specialist. This shift has not only changed how cases are won, but has fundamentally restructured how a high-tier divorce lawyer bills their time and maximizes their annual earnings. Imagine a specialized matrimonial attorney named Kevin practicing in Northern Virginia in 2026. Kevin represents the new breed of data-driven litigator. In the past, discovery meant exchanging boxes of paper bank statements and handwritten ledgers. Today, Kevin deals with terabytes of encrypted data, cloud-synchronized metadata, and wearable device logs. This explosion of data has created a massive opportunity for billable hour expansion. Historical trends show that in the year 2000, discovery tasks accounted for approximately 15% of a divorce lawyer's total billable time. By 2026, that figure has climbed to nearly 45% for high-stakes cases. This means that nearly half of the revenue generated by elite firms is now tied directly to the identification, preservation, and analysis of digital footprints. The surveillance economy has introduced what we call the metadata premium. Metadata is the hidden data behind the data, the timestamp on a photo, the GPS coordinates of a social media post, or the edit history of a spreadsheet. For a lawyer like Kevin, the ability to interpret this data is worth a significant hourly premium. In 2026, a lawyer who can walk into a courtroom and explain the significance of an automated smart home log that shows a spouse was not where they claim to be can command a rate 20 to 30% higher than a general practitioner. The market in 2026 views these lawyers as par technologists, and technology-adjacent legal work has historically commanded higher price points across all sectors of the law. Let us look at a case study involving a character named Linda and her husband, Mark. Mark, a high-earning executive, claimed during the initial stages of their divorce that he was living a modest lifestyle and that his income had plateaued. However, Kevin, acting as Linda's attorney, initiated a deep-dive digital discovery process. In 2026, this does not just mean looking at emails. It involves a subpoena for Mark's Tesla telemetry data, his Oura Ring health metrics, and his Amazon Alexa voice logs. By analyzing the Tesla's charging history, Kevin was able to identify frequent trips to an undisclosed $3 million waterfront property in a neighboring state. By cross-referencing this with Mark's smartwatch data, Kevin could prove that Mark's heart rate and sleep patterns indicated he was spending several nights a week at this location. From a salary perspective, managing this level of discovery is incredibly lucrative. Kevin does not do the forensic heavy lifting himself. He manages a team of forensic IT consultants. In the modern firm model of 2026, the lawyer often adds a management fee or a markup on these specialized services. While the forensic expert might bill $300 per hour, the law firm may bill the client for the time spent reviewing, synthesizing, and integrating that data into the legal strategy at the lawyer's full rate of $700 or $800 per hour. This creates a multi-layered revenue stream where the complexity of the digital world effectively subsidizes the lawyer's high annual salary. Furthermore, we must examine the cost of the digital arms race. In 2026, the wealthiest spouses use ghost apps, encrypted messaging platforms like Signal or Telegram, and even burner virtual private servers to hide their activities. This has led to a statistical surge in the use of e-discovery platforms like Relativity or specialized AI-driven matrimonial software. These tools use predictive coding to scan millions of messages for keywords related to hidden assets or infidelity. For a lawyer, the potential outcomes of using this technology are twofold. It dramatically increases the efficiency of finding the smoking gun, and it allows the firm to bill for the high-end software licenses required to run these searches. The historical data suggests that firms which heavily invest in e-discovery technology see a 25% higher net profit margin than those that rely on manual document review. We also have to consider the psychological impact of the 24/7 digital footprint on the lawyer's workload. In 1990, a lawyer might receive 1 or 2 phone calls a day regarding a case. In 2026, Kevin is inundated with screenshots from social media, alerts from tracking apps, and frantic messages about a spouse's latest digital activity. This constant stream of microevidence has led to the rise of the high-frequency billing model. While each individual interaction may only take 6 minutes, the aggregate effect over a month is a significant increase in total hours billed. Statistical reviews of modern law practices show that the move to mobile integrated legal practice has increased the average billable day by 1.2 hours compared to the pre-smartphone era. This represents an annual salary boost of nearly 15 to 20% just by capturing the small interactions that used to go unrecorded. However, this data-driven world comes with significant risks that also contribute to the lawyer's salary through a risk premium. In 2026, the Electronic Communications Privacy Act and the Stored Communications Act are more complex than ever. A lawyer who accidentally uses illegally obtained digital evidence can face severe professional sanctions or even criminal liability. Because the stakes are so high, clients are willing to pay more for a lawyer who has the technical and ethical sophistication to navigate the fine line between legal discovery and illegal hacking. High-risk niches in the legal profession historically pay more because the cost of an error is so high. This is why a top-tier divorce lawyer in 2026 often earns more than a corporate lawyer of similar experience. The personal liability and emotional volatility of the work are factored into the market rate. To truly understand the salary math, we must look at the step-by-step breakdown of a modern digital discovery bill. For a high-net-worth case in 2026, a lawyer might bill 20 hours for initial data preservation, 50 hours for overseeing forensic imaging of devices, and 100 hours for the review of the resulting data. At an average rate of $600 per hour, this single phase of the divorce generates $102,000 in gross revenue for the firm. When you consider that a partner like Kevin might manage 10 such cases simultaneously, you begin to see how the 7-figure salary becomes a statistical certainty for the elite of the profession. As we conclude this deep dive into the digital surveillance economy, we have to look beyond the domestic borders of the United States. While digital footprints are hard to hide, they are nothing compared to the complexity of international shell companies, offshore trusts, and global asset shelters. The highest-paid divorce lawyers in 2026 are not just technologists. They are global financial hunters. In the next part, we are going to explore the international asset hunt. We will look at the salary of the global matrimonial lawyer, the professional who flies to Zurich, the Cayman Islands, and Singapore to track down the wealth that a digital search could never find. We will analyze the multi-jurisdictional fee structures and why a lawyer who can speak the language of international banking is the most expensive person in the room. Get ready for Part 7, where the search for the salary goes global. The global matrimonial lawyer of 2026 operates in a realm that feels more like a high-stakes intelligence agency than a traditional law firm. To understand how these practitioners reach the absolute peak of the legal salary pyramid, we must analyze the shift from domestic litigation to multi-jurisdictional asset recovery. In the year 2026, wealth is no longer stationary. For the ultra-high net worth individual, a marital estate is rarely confined to a single state or even a single continent. It is spread across real estate in London, shell companies in the British Virgin Islands, private equity in Singapore, and sophisticated trusts in South Dakota or Nevada. For a specialized attorney, this geographical complexity is the ultimate revenue driver. Imagine a character named Alexandra, a lead partner at a top-tier international family law firm in New York City. Alexandra does not bill like a standard local attorney. Her salary is a reflection of her ability to navigate the conflicting laws of different nations simultaneously. In 2026, the historical trends show that the number of divorces involving cross-border assets has increased by 300% since the early 2000s. As a result, the potential outcomes for Alexandra's annual income have shifted from the high hundreds of thousands into the multi-million-dollar range. When a client walks into her office with a $500 million global estate, the initial retainer alone can reach $250,000. To justify these numbers, we have to look at the step-by-step mechanics of the international asset hunt. The first billable goldmine is the jurisdictional battle. Before a single asset is divided, lawyers spend hundreds of hours arguing over where the divorce should even take place. This is known as forum shopping. In 2026, the difference between a divorce settled in London, which is often seen as the divorce capital of the world for its generous settlements, versus a divorce in a more restrictive jurisdiction can be worth tens of millions of dollars to the client. Alexandra might bill 150 hours just on the initial research and filing of jurisdictional motions. At an international premium rate of $1,200 per hour, this initial phase generates $180,000 in gross revenue for the firm before the discovery process even begins. Historically, tracking money across borders was an exercise in futility. In the 1990s, if a spouse hid money in a Swiss bank account, it was effectively gone. However, the post-2010 era of transparency, including the Common Reporting Standard and the various leaks like the Panama Papers, has changed the game. In 2026, the money is findable, but it is expensive to find. This is where the international lawyer's salary truly accelerates. Alexandra acts as the hub of a global wheel. She manages local counsel in 3 or 4 different countries. Consider a case study involving a tech founder's divorce. The husband has established a series of offshore trusts that hold his intellectual property rights. To pierce these trusts, Alexandra must coordinate with a solicitor in the Cayman Islands and a barrister in Hong Kong. From a billing perspective, Alexandra applies a management fee or a supervisory premium to the work performed by these foreign experts. If the Hong Kong counsel bills $20,000, Alexandra's firm might bill an additional $5,000 for the time spent reviewing, translating, and integrating that work into the US-based litigation strategy. This arbitrage of global legal talent allows the lead U.S. attorney to scale their revenue without personally performing every minute of labor. The complexity of these cases also leads to a surge in billable hours through the process of letters rogatory. This is a formal request from a U.S. court to a foreign court for judicial assistance. In 2026, drafting these requests is a highly specialized skill. Each country has different evidentiary standards. A mistake in a letter rogatory sent to Switzerland can set a case back by 6 months and cost the client hundreds of thousands in wasted fees. Because of this risk, the lawyers who have a proven track record of successful international discovery command the highest salaries in the profession. They are not just lawyers, they are master coordinators of international diplomacy. We must also look at the rise of the international travel billable. While digital communication has reduced the need for some travel, the highest-earning lawyers in 2026 still find themselves on international flights for crucial depositions or high-level settlement conferences. Historical trends suggest that for elite matrimonial partners, travel-related billing can account for up to 10% of their annual gross revenue. In 2026, this includes not just the time spent in the air, but the premium for being out of the office and away from other billable matters. A 3-day trip to Singapore for a deposition can result in 36 to 48 hours of billable time when portal-to-portal billing is applied. Another significant factor in the 2026 international salary data is the use of international private arbitrators. For many ultra-wealthy clients, the privacy of a public courtroom is a non-starter. They prefer to hire a retired judge or a top-tier specialist to act as a private arbitrator. These arbitrators themselves earn massive salaries, often charging $10,000 to $20,000 per day for their services. The lawyers representing the parties in these private proceedings must be of an equal or higher caliber. This creates an insular economy of high-priced talent, where the standard rules of legal billing are replaced by what the market for absolute privacy will bear. Data from recent 2026 industry reports indicates that lawyers who specialize in international family law have a 45% higher average salary than those who focus purely on domestic cases. This is partly due to the high barrier to entry. To do this work, you need a deep understanding of the Hague Convention, international tax treaties, and the nuances of foreign property law. In 2026, we are also seeing these lawyers integrate with global wealth management firms. Instead of waiting for a divorce, they are being hired to audit global marital estates to ensure that prenuptial agreements are enforceable in every jurisdiction where the couple owns property. This proactive, preventative work is a new and growing revenue stream. Imagine Alexandra being paid a $100,000 flat fee every 3 years just to perform a global asset audit for a high-net-worth couple. This provides a level of salary stability that traditional litigation-based practices lack. It moves the lawyer from a reactive crisis manager to a long-term strategic advisor. However, as the asset hunt goes global, it also becomes more dangerous. In 2026, international divorce lawyers are increasingly targets for cyber espionage and data breaches. When you are tracking hundreds of millions of dollars across borders, you are a high-value target for hackers. The cost of cybersecurity for an international firm is now a major overhead expense. Yet, this too contributes to the salary floor. Only the most profitable firms can afford the military-grade encryption and security protocols required to handle these cases, which effectively narrows the competition and keeps the fees for the elite practitioners at an all-time high. As we look at the global trajectory of these salaries, we see that the divorce lawyer has evolved into a global financial architect. But no matter how much money is found or how many jurisdictions are involved, the final battle almost always returns to one place: the courtroom. And in 2026, the cost of a trial has reached levels that were unthinkable even a decade ago. We have tracked the money across the globe, but now we must look at the sheer, raw cost of the final confrontation. In the next part, we are going to break down the anatomy of the multi-million-dollar trial. We will look at the daily burn rate of a high-end litigation team. We will analyze the cost of expert witnesses, the psychology of the courtroom presentation, and why the final 30 days of a divorce can cost more than the previous 3 years of discovery combined. We are going to look at the trial premium and how a lawyer's salary can double in a single month of intense litigation. Get ready for Part 8, where we enter the courtroom and look at the financial explosion of the final trial. The financial explosion that occurs when a high-stakes divorce reaches the trial phase is a statistical phenomenon unlike any other in the legal profession. To understand the raw intensity of a 2026 trial, we must first deconstruct the concept of the trial burn rate. While the preparation leading up to this moment involves significant billable hours, the actual trial acts as a force multiplier for an attorney's salary. Imagine a lead litigator named Marcus, operating out of a high-end firm in Los Angeles in 2026. For Marcus, the trial phase is not just a battle of legal wits. It is a logistical operation that requires a massive infusion of capital and human resources. Historical trends show that in the mid-1990s, a standard contested trial might last 3 to 5 days. In 2026, due to the sheer volume of digital evidence and the complexity of global assets, a high-net-worth trial frequently extends into 3 or 4 weeks. During this period, the trial burn rate for Marcus's team can easily exceed $25,000 per day. This is because the lawyer is no longer working alone. A trial team in 2026 typically includes the lead partner, a senior associate, 2 paralegals, and a trial tech consultant. Every single one of these individuals is billing for every minute spent in the courtroom, every minute spent in transit, and every minute spent in the war room late into the night. Let us break down the math of a single trial day in 2026. Marcus, the lead partner, bills $950 per hour. His senior associate bills $600. The 2 paralegals bill $250 each. The trial tech consultant, who manages the advanced holographic evidence displays and real-time AI transcript analysis, bills $400. If the team spends 8 hours in court and an additional 6 hours in evening preparation, a standard 14-hour trial day, the gross billable revenue for that single day is $34,300. Over a 10-day trial, that is $343,000 in revenue generated by just one case. From a salary perspective, Marcus typically receives a percentage of this gross billing as a performance bonus, which is why the trial month is often the most lucrative month of his entire year. However, the salary of the divorce lawyer is also heavily influenced by the expert witness economy. In 2026, a trial is rarely won by the lawyer's rhetoric alone. It is won by the experts they provide. Historical data indicates that the cost of expert testimony has risen by 150% over the last decade. A forensic accountant who can trace crypto assets across decentralized exchanges may charge a retainer of $50,000 just to show up for the trial. Marcus manages these experts, and in many high-end firm structures, the firm applies a management fee to the coordination of these external specialists. This creates a secondary revenue stream that contributes to the overall profitability of the partner's practice. Imagine a case study where Marcus is representing a high-profile athlete in a dissolution involving $50 million in endorsements and real estate. The trial requires a child psychologist to testify on custody, a vocational expert to testify on the spouse's earning capacity, and a business valuator to determine the present value of future royalties. The total expert witness bill for a 14-day trial can reach $200,000. The lawyer's ability to successfully deploy these experts is what justifies their high salary. If Marcus secures a favorable outcome, the potential outcomes for his future client acquisition are massive. In the legal market of 2026, a trial win is the ultimate marketing asset, allowing Marcus to raise his hourly rate by another $100 for the following year. We must also analyze the trial premium clause. In many 2026 retainer agreements, firms include a specific provision that increases the hourly rate of the lead attorney once a trial date is set. This is a historical shift from the flat fee or standard rate models of the past. The justification is that a trial requires the attorney to clear their entire calendar and focus exclusively on one client, effectively preventing them from working on other billable matters. Statistical reviews of modern retainer agreements show that 40% of Tier 3 firms now implement a trial premium of 15 to 25%. This means Marcus's $950 rate might jump to $1,150 the moment he steps into the courtroom. The psychological landscape of the final 30 days is another factor that drives the financial explosion. This is known as the sunk cost phase. By the time a client reaches the month before trial, they have likely already spent $100,000 to $250,000 on legal fees. At this point, the statistical trend shows that clients become less price-sensitive and more focused on the final result. They are all in. For the lawyer, this results in an explosion of authorized work. Research, mock trials, jury selection simulations, and extensive witness preparation all take place in these final 30 days. The data suggests that for high net worth cases, the fees incurred in the final month before the verdict can equal the total fees spent in the previous year of discovery. To understand why this is so profitable for the attorney, we have to look at the success fee or result-based bonus. While many jurisdictions have strict rules about contingency fees in family law, meaning a lawyer cannot take a percentage of the final settlement, they are often permitted to accept a bonus for exceptional results if it is structured correctly and disclosed to the client. In 2026, these bonuses are becoming a standard part of the elite compensation package. A lawyer like Marcus might receive a $100,000 bonus if he manages to protect a specific family business from being liquidated. This bonus is pure profit, as it does not correspond to any specific hours worked, effectively skyrocketing his year-end income. Historical context is vital here. In 1970, a divorce lawyer would walk into court with a single yellow legal pad and their own memory. In 2026, Marcus walks into court with a team that resembles a small tech company. The technological infrastructure of a modern trial, including cloud-based evidence lockers, automated exhibit numbering systems, and real-time legal research AI, costs the firm thousands of dollars per month in licensing. However, the firm bills these as disbursements or litigation support fees, with a margin of profit included. This transition from manual labor to managed technology is how the top 1% of divorce lawyers have managed to increase their salaries at a rate that significantly outpaces general inflation. As we look at the raw data, the reality of a trial is clear. It is a high-cost, high-stakes event that functions as the engine of the lawyer's wealth. But what happens after the judge bangs the gavel? What happens when the trial ends but the fighting continues? In 2026, the end of the case is often just the beginning of the most complex financial phase, the post-judgment enforcement. The battle for the salary doesn't stop at the verdict. In the next part, we are going to dive into the world of contempt and enforcement. We will look at how lawyers continue to bill hundreds of thousands of dollars years after the divorce is technically over. We will analyze the strategies used to track down vanishing assets and the lucrative business of judgment collection. We are moving into the phase of the endless litigation loop, where a single divorce can provide a steady stream of income for a lawyer for over a decade. Stay with us as we uncover the secrets of the post-divorce economy in Part 9. The statistical reality of a final divorce decree in the United States is that it is often not the end of a legal battle, but rather a transition into a new, potentially decade-long revenue stream for the legal profession. Historical trends indicate that approximately 40% of all divorce judgments involving financial support or complex asset division face significant non-compliance issues within the first 24 months. For a divorce lawyer in 2026, this creates a secondary economic vertical known as post-judgment enforcement. When a judge signs an order for a $2 million payout or a $10,000 per month alimony obligation, that order is frequently just a piece of paper. The actual movement of those funds requires a specialized set of legal maneuvers that can be just as lucrative as the divorce itself. Imagine a specialized enforcement attorney named Ethan operating in a high-wealth corridor like Greenwich, Connecticut, in 2026. Ethan represents the evolution of the family law practitioner, who has pivoted away from the initial trial and into the world of long-term judgment collection. For Ethan, a case is never truly closed. In the historical model of the 1980s and 1990s, enforcement usually involved simple wage garnishments or placing a lien on a primary residence. These were low-complexity tasks that did not justify high billable rates. However, in the year 2026, the methods used to evade judgments have become technologically sophisticated, requiring a corresponding increase in the technical expertise and the salary of the lawyer chasing the funds. Let us analyze a case study of a character named Robert, a high-earning tech consultant who was ordered to pay his former spouse $1.5 million as part of an equalization payment. Following the trial we discussed in the previous part, Robert did not simply write a check. Instead, he utilized the decentralized nature of the 2026 economy to make his assets appear untouchable. He moved significant portions of his wealth into private liquidity pools and offshore digital vaults that do not report to standard U.S. financial institutions. This is where Ethan's specialized skills come into play. To enforce this judgment, Ethan must file motions for contempt of court, initiate third-party subpoenas to digital exchange platforms, and potentially coordinate with international authorities if the assets have crossed borders. The salary dynamics of this work are unique. Unlike the initial divorce, which is almost always billed hourly or via a fixed retainer, post-judgment enforcement in 2026 is increasingly moving toward a hybrid model. In some jurisdictions where ethically permitted, lawyers are structured to receive a percentage of the recovered funds, or more commonly, they apply a heavy premium to their hourly rate for enforcement actions due to the high conflict nature of the work. If Ethan spends 100 hours successfully uncovering a hidden $500,000 account and securing its seizure, his firm may bill at a premium enforcement rate of $1,200 per hour, generating $120,000 in revenue. Statistical reviews show that for top-tier firms, post-judgment work now accounts for nearly 20% of their total annual billings, providing a stable floor for partner salaries, even during months when no new trials are on the calendar. Furthermore, we must examine the economics of the modification industry. In 2026, the United States economy is defined by high volatility in professional incomes, particularly in the gig executive and tech sectors. A support order based on a 2024 income may no longer be sustainable by 2026. This creates a perpetual cycle of modification filings. Historical trends suggest that for every major economic shift, such as a market correction or a shift in industry-wide bonus structures, there is a 15 to 25% spike in motions to modify alimony and child support. For a lawyer, these modifications are not just one-off events, they are recurring billable opportunities. A single high-net-worth client might return to their lawyer 4 or 5 times over a 10-year period to adjust support amounts. This creates a client lifetime value that far exceeds the initial divorce fee. The role of contempt of court is also a major driver of the lawyer's salary. In 2026, filing for contempt is a strategic financial tool. When a party is found in willful contempt for failing to pay, many states allow the court to order that the non-compliant party pay the legal fees of the other side. This is a critical data point. It means that for an attorney like Ethan, the potential outcomes include the client getting the money and the opposing party being forced to pay Ethan's entire bill. This fee-shifting mechanism significantly reduces the financial risk for the client and encourages aggressive litigation, which in turn inflates the total billable hours recorded by the firm. We also have to consider the rise of the judgment-proof spouse as a statistical challenge. As individuals become more adept at hiding wealth behind corporate veils or complex trust structures, the lawyer's job becomes one of a corporate investigator. In 2026, the highest-paid enforcement lawyers are those who can successfully navigate the alter ego doctrine, the legal theory that a corporation or trust is simply a sham used to hide personal wealth. Proving this requires hundreds of hours of forensic accounting and corporate document review. Historical records from the early 2010s show that these corporate veil cases were rare in family law. Today, they are a standard part of the high net worth toolkit, adding a layer of corporate litigation fees onto the domestic relations bill. Step by step, the enforcement process in 2026 involves a specific escalation ladder. First, the lawyer issues a demand letter and a motion for a payment plan. If that fails, they move to asset discovery, utilizing the digital surveillance tools we discussed in Part 6. If the assets remain hidden, they move to the coercive phase, which includes the suspension of professional licenses, the freezing of passports, and in extreme cases, incarceration for civil contempt. Each step on this ladder represents an increasingly high level of technical filing and court appearance time. A lawyer who can successfully manage this escalation without overstepping legal boundaries is a high-value asset, commanding a salary that reflects their role as a private debt collector with the power of the court behind them. Data from 2026 industry surveys indicates that the average annual salary for a lawyer who specializes exclusively in matrimonial enforcement and modification is approximately $280,000. This is slightly lower than the elite trial specialists, but the overhead is significantly less. Enforcement specialists do not need the same massive trial teams or expensive courtroom tech. They operate in a more procedural, document-heavy environment. This means their net profit margin is often 10 to 15% higher than that of a litigation-heavy firm. It is the steady, reliable blue-chip stock of the legal world compared to the high-volatility, high-reward nature of the trial lawyer. As we look at the trajectory of the profession, it becomes clear that the divorce lawyer is no longer just there for the breakup. They are there for the long-term financial management of the conflict. But as we reach the conclusion of this masterclass, we have to look at the biggest question of all. What does the future hold? We have tracked the history from the 1960s to 2026, but the next decade promises a shift that could render the traditional billable hour obsolete. In the final part of this series, we are going to look at the future of the divorce lawyer salary. We will analyze the impact of fully autonomous AI judges, the potential for blockchain-based, smart marriage contracts that execute asset division automatically, and the rise of the mega firm that is threatening to put the solo practitioner out of business. We are going to look at the final data set, the projected earnings for the year 2030 and beyond. This is the ultimate look at where the industry is going and how you can position yourself to stay ahead of the curve. Get ready for Part 10, the final chapter in the statistical history of the American divorce lawyer. The evolution of the American divorce lawyer's salary reaches its most transformative inflection point as we look toward the year 2030. We have moved from the 1960s era of taboo and low-margin litigation into the 2026 era of high-tech forensic discovery and global asset hunting. But the data for the next 5 years suggests a paradigm shift that will fundamentally decouple legal earnings from the traditional billable hour. To understand where the wealth is moving, we must analyze the rise of predictive outcome modeling and the institutionalization of the family law firm. Imagine a lawyer named Thomas operating in the year 2030. Thomas is no longer selling his time in 6-minute increments. He is selling certainty. In 2026, we are already seeing the early adoption of AI-driven judicial analytics. By 2030, this technology will have matured into a standard requirement for high-stakes litigation. Historical trends show that the most significant cost in a divorce is the uncertainty of the trial. Thomas utilizes a platform that has ingested every ruling from every family law judge in his jurisdiction over the last 20 years. When a client asks about the potential outcomes of a specific alimony claim, Thomas doesn't give a guess based on experience. He provides a statistical probability of 87.4% based on the judge's history with similar asset profiles. For this level of data-backed strategy, the market in 2030 is shifting toward the project-based retainer. Instead of billing $800 an hour for research, Thomas bills a flat $75,000 strategy fee for the initial phase of the case. Because the AI performs the research in seconds, Thomas's effective hourly rate during those few hours of strategic oversight skyrockets to nearly $15,000. This is the ultimate evolution of the salary, moving from a labor-based economy to an insight-based economy. Case studies of early adopters in the 2025 and 2026 markets indicate that firms utilizing predictive modeling have already increased their net profit margins by 40% while decreasing the total hours worked per case. We must also analyze the impact of the smart marriage contract on future earnings. Imagine if, at the time of marriage, a couple's assets were governed by a decentralized autonomous organization or a DAO. In this scenario, the prenuptial agreement is not just a document, it is a piece of code. If the legal conditions for a separation are triggered in 2030, the smart contract automatically executes the division of digital assets, real estate titles, and bank accounts. While this might seem like it would put divorce lawyers out of business, the statistical reality is quite different. The lawyer's role simply shifts upstream. Thomas is now hired as a legal architect to draft the logic of the code before the wedding. The fee for a smart marriage architecture project in 2030 is projected to range from $20,000 to $100,000, depending on the complexity of the assets involved. The historical trend here is clear. Whenever technology automates a routine task, the value of the professional who oversees that technology increases. The divorce lawyer of the future is part programmer and part financial engineer, and their salary reflects this hybrid expertise. The next major shift is the institutionalization of the family law practice. Historically, family law was the domain of the solo practitioner or the small partnership. However, data from 2024 to 2026 shows a surge in private equity interest in the legal sector. Institutional investors are beginning to buy up successful family law firms and consolidate them into regional or national brands. For the individual lawyer, this changes the salary structure from a volatile partnership distribution to a high base salary plus equity options and performance bonuses. In a case study of a consolidated firm in 2026, a senior associate no longer earns a flat $150,000. Instead, they receive a base of $220,000 plus a 15% bonus tied to the firm's overall efficiency and client satisfaction metrics. This institutional model provides the scale necessary to afford the high-cost technology required to compete in the 2030 market. Statistical reviews suggest that lawyers in these mega firms will see a 25% higher salary floor than those struggling as solo practitioners without the capital to invest in AI and forensic tools. Let's look at the projected salary brackets for the year 2030. Based on the historical growth rate of the Legal Services Index and the added value of technological multipliers, we can estimate 3 tiers of earnings. Tier 1, the generalist/volume practitioner, will likely see a salary range of $110,000 to $160,000. These lawyers will be in constant competition with DIY AI platforms. Tier 2, the specialized litigator/mediator, will move into the $350,000 to $600,000 range. Tier 3, the high net worth legal strategist or architectural coder, will regularly see 7-figure incomes, with the top 1% of the profession exceeding $3 million in annual compensation. However, the most valuable asset a divorce lawyer will possess in 2030 isn't their data or their code. It is their empathy IQ. As more of the technical work is automated, the human element becomes the rarest and most expensive commodity. A computer can divide a bank account, but it cannot navigate the emotional trauma of a custody dispute or the psychological nuances of a high-stakes negotiation. Historical trends in professional services show that as AI commoditizes technical skill, the soft skills see a massive price premium. In 2030, a client will pay a lawyer $1,500 an hour not because they can find a hidden asset, but because they can provide the emotional stability and strategic wisdom needed to reach the finish line. Step by step, the path to these potential outcomes requires a complete retooling of the legal education and career path. The lawyers who will command these salaries are those currently studying data science, behavioral psychology, and international finance alongside their law degrees. We are seeing a move away from the lawyer as an advocate toward the lawyer as a crisis manager. As we wrap up this 10-part deep dive, we have seen how the divorce lawyer has transformed from a marginalized practitioner in the 1950s into one of the most technologically advanced and highly paid professionals in the 2026 economy. We have analyzed the raw numbers, the historical inflection points, and the secret mechanics of the billable hour. The history of the divorce lawyer's salary is, in many ways, the history of the American dream and the American nightmare, reflected in the cost of the legal systems we use to govern our most intimate failures. The data is clear. The industry is not shrinking. It is evolving. The $50 billion market of 2026 is projected to reach $75 billion by 2035, driven by the increasing complexity of global wealth and the rising cost of specialized talent. For those who can master the intersection of technology, finance, and human psychology, the financial potential is virtually limitless. The question is no longer whether you can make a high salary as a divorce lawyer, but whether you can evolve fast enough to justify it in a world where data is king. The story of legal compensation doesn't end here. While we have focused on the matrimonial attorney, a new and even more volatile sector is emerging in the legal landscape. As we look at the rise of the digital world, a new breed of practitioner is beginning to outpace even the highest-paid divorce lawyers. In our next series, we will dive into the statistical world of the cybertort attorney and the billion-dollar class actions of the metaverse. The battlefield is shifting again, And the numbers are even more staggering. Keep your eyes on the data because the future of the legal economy is moving faster than the law itself.